We shift our attention now to a limit on contractual enforcement that focuses primarily on the process of reaching an agreement. The unconscionability doctrine allows a court to find a contract void or to reform an existing contract by removing the unconscionable clause. Although it's internal to contract law itself, this doctrine serves a similar purpose to and arguably resembles a consumer protection law. That's why I've placed it in the category of regulation. You've read two appellate opinions in the case of Williams against Walker Thomas Furniture Company. If you were puzzled about how this case eventually ended up in a federal court of appeals, let me explain the jurisdiction very briefly. The District of Columbia is a federal territory under the control of Congress. At the time of this case, the D.C. Court of Appeals did not have final say over D.C. law. Instead, the Federal Appeals Court for the D.C. Circuit acted as a Supreme Court for the district. Congress changed the law in 1970, and now the D.C. Court of Appeals itself is the final arbiter of D.C. law. In Williams 1, Judge Quinn reluctantly decides to enforce the furniture company's pro rata payment clause. The effect of the clause was to allow the furniture company to maintain a security interest in everything Ms. Williams had ever bought from them. For that reason, it's also sometimes called a cross-collateral clause. But if the court dislikes the clause so much, what makes them enforce it? Well, the simplest answer is the so-called duty-to-read doctrine. As you see in paragraph 5, many cases establish that someone who signs a written contract is bound by its terms, even if she hasn't read them or alleges later that she didn't understand them. The duty-to-read doctrine is a powerful force that ordinarily bars claims like the one Ms. Williams is making here. Notice that the court also observes that no statute or binding precedent prohibits what it calls the furniture company's possible sharp practice and irresponsible business dealings. Although they enforce the contract, the court issues a plea to Congress for corrective legislation. So how in the world does the D.C. Circuit manage to reach almost the opposite conclusion? Please pause the video now and review the opinion to be certain that you understand exactly what arguments enable Judge Wright to reach a different result. As you read, Judge Wright finds persuasive legal authority in judicial decisions from other jurisdictions. He concludes that the common law allows courts to refuse to enforce unconscionable contracts. There's nothing too surprising in this part of his analysis. But what about the fact that Congress only enacted the UCC, including Section 2302 on unconscionability, after this contract was executed? So the UCC rule doesn't govern this transaction. The furniture company could argue that Congress only needed to enact Section 2302 if no doctrine of unconscionability currently existed. The new enactment thus implies that the doctrine is new and Ms. Williams should lose. Judge Wright gives us a subtle response to this argument. He points out that this provision of the Code, along with many others, is derived from pre-UCC case law. Congress's enactment of Section 2302 thus confirms and codifies the pre-existing common law rule of unconscionability. On this interpretation, the later enactment helps rather than hurts Ms. Williams's argument. Notice also that Judge Wright doesn't actually hold that the pro rata payment clause is unconscionable. Instead, he remands the case to the trial court. The parties then settled their dispute before any further proceedings. Unfortunately, the terms of the settlement aren't known. But surely Ms. Williams got back the furniture for which she had paid in full. So what's the doctrinal standard that the trial court was supposed to apply on remand? In paragraph 7, the opinion refers to an absence of meaningful choice and contract terms unreasonably favorable to the other party. We can also compare the statutory version in UCC Section 2302. Comment 1 tells us that the basic test is terms that are so one-sided as to be unconscionable. And we learn that the principle is one of the prevention of oppression and unfair surprise. Both of these are pretty vague standards, and the UCC's basic test is arguably circular. So perhaps unconscionability is like Justice Potter Stewart's famous approach to obscenity. I know it when I see it. Despite, or perhaps because of this ambiguity, you should be aware that courts use unconscionability doctrine quite sparingly. An unconscionability claim is truly a last resort when you've exhausted all other legal options. In addition to talking about absence of meaningful choice, Judge Wright also refers to unequal bargaining power. We should consider briefly what that term might mean. Here are a few possibilities. How about take it or leave it offers? Did Ms. Williams have any choice about the terms or the price of the stereo? No. But we can also ask whether you have any choice about the terms or the price when you buy a keg at Harris Teeter or rent a car from Hertz. Again, the answer is no. So non-negotiable offers are far too common to be the basis for defining unconscionability. And in most cases, we expect that markets constrain sellers and force them to offer competitive terms, or go out of business. But suppose we're dealing with a monopolist. In this case, any market check on prices and terms is less obvious. Ask yourself, though, whether we should expect monopolists to impose absurdly unfavorable terms on their customers. Probably not. The reason is that even a monopolist will drive away customers and lose revenue and profit by imposing terms that customers don't want. Imagine, for example, that the only car dealer in town insists on selling every new car with a trailer. Some people want trailers, but many don't. They won't value it. And these potential customers may decide to keep their old car, or take the bus, or ride a bike instead. The monopolists can do better by selling cars for the profit-maximizing price, and then offering trailers also at the profit-maximizing price. Unwanted contract terms are a lot like adding a trailer to every sale. So ironically, the monopolist's self-interest deters consumer exploitation. Another possible understanding of unconscionability focuses simply on unfavorable terms. What about the idea that getting a bad bargain should be grounds for finding unconscionability? As it turns out, the UCC itself speaks directly to this point. Section 2302, Comment 1, says that the principle of the section is not to disturb, quote, the allocation of risks because of superior bargaining power. Thus, the Code, at least, specifically rejects the idea that unequal bargaining power should void an agreement. This fact tends to narrow application of the doctrine considerably. Finally, recall that the textbook notes draw a distinction between substantive and procedural branches of unconscionability doctrine. Substantive unconscionability refers to the terms themselves, and this branch of unconscionability doctrine depends on making a potentially controversial normative judgment about the contract. A court needs to say why Ms. Williams, for example, shouldn't be buying a stereo on these credit terms. One possibility is to appeal to fairness and conclude that the company has wronged Mrs. Williams. Or the court might paternalistically argue that she doesn't need and can't afford a stereo. Or they could focus on third-party effects, such as the fact that losing all of her furniture also hurts her children. Or finally, the court might assert that Ms. Williams misperceives and underestimates the risks of the pro rata payment clause. It's not too difficult to come up with counterarguments that raise doubts about whether courts should invoke these rationales for non-enforcement. I invite you to use the Piazza discussion forum to defend or attack any or all of these arguments for invoking substantive unconscionability. By contrast, procedural unconscionability focuses on contract formation, Under this branch of the doctrine, the court must find a process defect that prevented one party from understanding the agreement. Courts are by far the most receptive to procedural unconscionability. Thanks for listening.